My lord, permission be granted to start the session.
Okay, yes, please. You may
Good afternoon.
start.
Yeah, thank you, Lordship. Good afternoon, Honorable Sri Justice Sunil Ambwani sir, Court Manager colleagues. Today, we have gathered here for the webinar on the topic Court Manager's Role in Dispensation of Justice in Court System by Honorable Sri Justice Sunil Ambwani, former Chief Justice of Rajasthan High Court and former Chairman of E-Committee, Supreme Court of India. I welcome Honorable Sri Justice Sunil Ambwani sir for this webinar and thank for your Lordship valuable time given to all the court managers. Now I request Khushi Kochar to introduce the Honorable Lordship.
Good afternoon, everyone. First of all, I would like to thank Court Manager Mr. Punch, who gave me this opportunity of introducing our chief guest, Honorable Retired Justice Shri Sunil Ambani sir. His Lordship has done his law degree from University of Allahabad in the year 1975 and then practiced in the Honorable Allahabad High Court from 1976 to 1985 and then went to practice in Honorable Supreme Court in the period 1985 to 1992. His Lordship during his practice phase have taken keen interest in civil and constitutional matters. His Lordship in the year 1986 passed the Advocate on Record
Charu.
exam and was elevated as permanent judge of Honorable Allahabad High Court in the year 2001. His Lordship, during his tenureship as a judge, was also the chairman of the Allahabad Mediation Center as well as the Computerization Committee. His Lordship has served the bar from both the sides very elegantly. He has also written an elaborated report on justice administration, case and court management. His Lordship was appointed as the Chief Justice of Rajasthan High Court on 24th March 2015. His Lordship also became the chairman of E-Committee of Honorable Supreme Court in 2016. We are extremely elated that His Lordship has graced us with his presence by taking out some time from his busy schedule. Now, I would like to request Your Lordship to share his words of wisdom.
Lordship, your voice is not audible.
Lordship, kindly switch on your mic, Lordship.
There is a second option, leave video or leave audio. Okay. Okay.
You are muted. अब आपकी आवाज सुनाई नहीं देगी.
Hello.
Yes, Lordship.
Can you hear me
You
now?
are unmuted.
Yes.
अब आपकी
Am I
आवाज
audible?
सुनाई देगी.
Yes.
Okay.
Yes.
You
So
are
I'm beginning.
muted.
Okay.
अब आपकी आवाज
Lordship,
सुनाई
could you
नहीं
please share
देगी.
the web camera?
Share the web camera.
Share webcam.
Yes. Is it okay now? Web sharing. Is it okay? Can you see me?
1 second.
Hello.
Not
Can
at.
you see me now?
Not yet.
I'm punching the third button.
Okay.
There's something. Web camera. Is it okay? Can you see me now? Hello.
Yeah. We are unable to see you at the moment. 1 second.
Okay. I'm not able to click on this
Rahul sir?
video button. You can hear my voice.
Yes, Lordship.
You are unmuted. अब आपकी आवाज सुनाई देगी.
Huh? Yes. Yes. Okay. Share, share camera. This one. Yes. I'm clicking it, but there is a I'm clicking on that button, but nothing is happening. Refresh. No error message is there. Yes. Refreshing the screen. Refresh the screen. Which is the button to refresh the screen? Top. Top left arrow and circle. F5.
You are muted. अब आपकी आवाज सुनाई नहीं देगी.
Hello.
Yes, Lordship. We are able to hear you now.
Yes, I can also hear you, but I think the picture is not coming.
You are
Yes, now the
unmuted.
picture is coming.
अब आपकी आवाज सुनाई देगी.
Okay, I've done it. Yes. Is it
Okay.
okay
Yeah.
now?
Yes, yes.
You can see me clearly. You can also hear me.
Yes.
Okay. Can I start now?
Yeah, please.
All right.
You are muted. अब आपकी
Welcome and
आवाज
namaskar
सुनाई
to
नहीं
everyone,
देगी.
all the participants, the court managers. It's a pleasure to join you on this webinar. Unfortunately, in the very difficult circumstances of COVID pandemic, we all are facing temporary or momentary difficulties because of this COVID-19. And we hope that we'll be able to come out of it without much loss of lives. We are all under lockdown. Today is the 52nd day of the lockdown in the entire country. Almost all the countries in the world are also under lockdown. So this is one of the methods to connect with each other, either by Skype or webcam or this arrangement which has been made by Kishtab. Day before yesterday, you must have seen the webinar from the Supreme Court also when they inaugurated the e-filing module, which was presided by Honorable the Chief Justice of India and Justice Chandrachud. I'm really very happy to associate with you all over again. The last I met some of you was in National Judicial Academy in Bhopal in 2017, along with Justice Ramakrishna Reddy, Justice Chauhan, Justice Ani, and Mr. Atul from the Ministry of Justice. That was a seminar in which we deliberated and discussed over the role and functions and duties of the court managers. My introduction to court managers begins from the year 2011 in Allahabad, where I was a judge. There was a committee formed to recruit and also to prepare the details of the duties and functions of the court managers. And fortunately, the Justice R.K. Agarwal, who went up to the Supreme Court, Justice Jatin Singh, who became the Chief Justice of Chhattisgarh, they were also members of the committee. The committee was given a task of recruitment as well as laying down the duties and responsibilities. Now, at that time, we found that though in the 13th Finance Commission report, which came in 2009 and was made applicable 2010 to 2015, the provision has been made for court managers, and out of 5,000 crores, 300 crores was earmarked for court managers. But there was no details given as to what should be the qualification, how the court managers should be recruited. A broad outline was given that they will be assisting the courts in functions of the court management and also be assisting the district judge in discharge of his duties and responsibilities towards the administration and management of the court. But these are very vague. So in those meetings, we prepared those duties and responsibilities. And as proposed, we also prescribed the qualifications, that is a Master of Business Administration and 5 years experience in UP. Now, that was later on found to be not a very good idea because some other states gave 2 years experience as a qualification, eligibility for appointment. Initially, we did not get sufficient number of candidates. The posting also was a little difficult because most of them wanted the posting, especially the women candidates in their own districts. We tried to manage and accommodate as many as possible. But we also were little ambitious, and we gave 2 court managers at Allahabad and 1 to Lucknow in the high courts. Whereas the entire scheme was for district courts, not for the high courts. And immediately we came across a problem as to how to induct the court managers. What should be the training program? Because most of the court managers were not aware of the court processes, and hardly 1 or 2 had the LLB degrees. So at that time, an idea was floated to consult some management institutes. We had a Army Management Institute at Ghaziabad, which volunteered. But when we decided to go for an Indian Institute of Management at Lucknow, and we requested them to prepare a module for the training of the court managers. During my time, 2 batches took the training. In one of the concluding sessions, I also went there. The feedback which we got from the Indian Institute of Management was that all the managers, court managers appointed, are very enthusiastic. They want to learn. But the basic problem which the court managers were facing was that they had all done MBAs or MBMs in the business models. They all were trained and groomed to function in a corporate atmosphere, where profit motive is the main consideration. And their entire training, whether it's a training for processes of the corporate management, human resource management, budgeting, other things, was trained at a financial model. In courts, we don't have that financial model. Courts is basically a service-oriented institution where justice is dispensed in accordance with the law under the directions of the High Court and the Supreme Court. And the state does not have much role to play. Making money or making profits is not the consideration. So most of the court managers who went to train at IIM were feeling a little difficult to understand. But then the professors there, they had prepared a program. I would recommend that in all the states, they should approach the IIM Lucknow where they had prepared a program of training. And that should be adopted for all the states, unless all the states have actually taken steps and prepared their own models. And this training should be imparted in the judicial academies, state judicial academies in the respective states. I found that because, now I'm a retired person. I retired in 2015, almost 5 years. And I retrospect that we, the brother judges, we claim a lot of understanding of the court systems and processes, whereas we really don't know anything about it. We have very little experience. But the authoritative manner in which we conduct ourselves, calling ourselves lordships and trying to manage the institutions, sometimes becomes counterproductive.
My lord,
We have to, yes.
video is not visible.
Again, video, okay, third one. I think it's coming.
Okay.
Is it there?
Yes, lordship.
Can you see me?
Yeah.
Okay. Okay.
Please continue.
Okay. So I'll continue. So that was the difficulty we felt. Now, I tell you, there was a little flaw in the entire way the concept of court managers was conceived. Let me tell you something about the 13th Finance Commission also. What happened that at that time, Mr. Moily was the law minister in the UPA government. And they decided that they should do something about the judiciary. They were very much concerned about the judiciary, the arrears, and all that. The government felt that the judiciary needs some help from the central government by way of finances. Now, there were recommendations of the law commissions, some judgments of the Supreme Court also regarding management of arrears, boosting up the courts, and to have the fast-track courts, court management systems, improving the buildings, overall development of the court systems. So Mr. Moily had 4 conferences, East, West, North, South of the country. And one of the conferences, one of my friends, Justice Yatin Singh, who later on became the Chief Justice of Chhattisgarh High Court, he participated. He's a very enthusiastic person. And he gave his best in that conference and made several suggestions. When the report of the 13th Finance Commission came, he found that nothing that he had spoken was taken care of, not even a mention was made of those suggestions. So he requested the law secretary. He told the law secretary that, but you have not considered our suggestions. So the law secretary told him, now this is interesting, the law secretary told him, so who said that we will consider your suggestions? You were called there only to participate so that we may, whenever we may have a report, we can say in the report that we have consulted the relevant persons. That is how the court managers were conceived. This was entirely a plan of a proposal of the Department of Justice. And the minister had introduced the system of court managers along with fast-track court, morning, evening courts, heritage buildings. Some of the proposals, some of the recommendations were entirely had nothing to do with the court functioning, like improvement of the heritage buildings. Whereas at that time, several heritage buildings were about to be brought down with the new constructions of the court and more effective way of managing their spaces. Anyways, so that is how the court managers are conceived. And the 13th Finance Commission, with the total outlay of 5,000 crores, 300 crores was marked for court managers. It was left entirely to the high courts to recruit and to fix the duties and responsibilities. Now, in the committee of recruitment and preparing the module of duties and responsibilities, we found that disbursement of the funds which have been allotted had a lot of difficulties because the entire thing, proposals of the High Court, even the appointments and the lists, and the release of the money had to be reviewed by the High Level Committee, HLC, which was given in the 13th Finance Commission, and that is how the government functions. HLC consisted of the Chief Secretary and Secretary of Finance and the Law Secretary. And they would review each and every proposal that we submitted. And they were not very happy about the way the High Court was proceeding to develop their own institutions. Now, so far as the court managers are concerned, I remember that although the recommendations were made applicable from 2011 onwards, and we could prepare the selections and make the selections and prepare the duties and responsibilities, it took about 2 years for the funds to be released, persons to be appointed and posted, and the first batch was appointed in 2013. By the time 2 years were lost. And you all know that the 13th Finance Commission, only 20 to 25% of the funds could be utilized. And some of the proposals did not work at all, like the proposals of morning evening courts in some of the states. All right. So we started with the court managers and we posted them. And then we also prepared for their training at IIM Lucknow and many other places the trainings were imparted. But when they went to in the court systems, they reported to us that they are not welcome at all because the district judge was not prepared to part with any of the functions to them. I met some of the district judges and I asked them, why are you not giving them work? We have already prepared the duties and responsibilities. Why are you not allowing them to work? Now, the district judge would not admit that he requires your services. He felt that suppose that he needs your work, that he's admitting his own deficiencies and faults. So we had to encourage them to make use of your services. We also found that most of the court managers have not been even provided the sitting spaces at the court. So we asked them, all of them, to at least pair one room with a good telephone and internet connectivity. Then we also sanctioned the budget out of the Hello.
Yeah, Lordship, we are able to
Hello.
listen to you. Again, the video
Can you
option.
yes, video option. I'm refreshing it.
Yeah.
Yes. Can you see me now? Hello.
Just a second. Yeah, Lordship, we are able to see.
Can you see? Can you hear me?
Yes, yes.
Okay. Should I continue?
Please continue.
Okay.
Please continue.
So we asked them to provide a computer and an assistant. And then we requested, it took a lot of time to request the district judges to provide you work. Now, this is just a background. Now let us immediately come to what happened thereafter. The 13th Finance Commission funds exhausted, or rather I'll say the period exhausted, not the funds, in 2015. And in the 14th Financial Commission recommendations, there was absolutely no provision for court managers. I don't know what happened. What was the feedback? Who told the central government not to continue the funds? But what happened that the state governments stopped funding also because they said this is the central government project. We have nothing to do with it. By the time in some of the states, including UP, I was there, and I believe in Maharashtra mostly, the court managers were proving themselves to be very efficient. and they made their place in the court systems. So in most of the states, the High Court made recommendations that they should provide funds. Now that was a big problem. Most of the states did not accept it. In some of the states, when I went to Rajasthan in 2015, when court managers had to approach the High Court on judicial side, and on judicial side, an interim order was passed by Justice Kaur to continue the funding and to allow them to continue. You know, it was a battle almost for all the court managers in the entire country to persuade their state governments. Instead of providing them regular pay scale and opportunities of upward movement and promotions, the funding itself was stopped. Now, what happens is that it state governments do not take any interest in central projects until and unless they have funds. And to persuade the state governments to have a provision for where the central government had already provided, like court managers, it was very difficult to persuade them. In many states, the writ petitions were filed, but they did not yield good results. And it took about 3 years' time in that All India Judges Association case, the judgment of Justice Deepak Mishra, that in 2018, that again recommendation was made, and this time on judicial side by the Supreme Court, that yes, there is a need of court managers. They are virtually indispensable to the court systems. They're functioning very well. And this time, the Supreme Court in the All India Judges Association case of 2018 also laid down broadly as to what the court managers are required to do. Now, what I feel is that with this background, in my personal view, almost all the states should now accept court managers as indispensable persons in the court systems. Now, this is the background. Now I'll come, what is the real problem? The real problem was in the conception of the post of court managers, the very idea of court managers, when it was conceived as helping the dispensation of justice in courts. Do you know why I have chosen this topic today? Court managers' role in dispensation of justice in court systems. This is in fact a negative topic. The court manager is not supposed to help in dispensation of justice. He is supposed to provide those services. I think the video is again gone.
Video, yes. Yeah, Lordship.
Yes, I'm refreshing it. Hello. Yes, it has come back, I think.
Yeah, Lordship.
Can you see me now?
Yes. Please continue. So far, excellent, Lordship.
Yes. So, just a minute. Yes, I think I've come back.
Yeah, we are able to hear you. We
Yeah.
are
Should I
able to.
Should I continue?
Yeah, please.
Yes. Now, this topic itself, today's topic, court managers' role in dispensation of justice in court system, is slightly misleading. I have deliberately put it. Here is the paradox. The paradox is dispensation of justice. Now, dispensation of justice is not the function of the court managers. Dispensation of justice is the function of the judges. The court staff helps them. The court staff is not competent. With the passage of time, so many new things have come. The IT structures, the e-procurement structures, and the new softwares, especially the CIS-1 and then CIS-2 and CIS 2.1. Now, the court staff is not very competent with it. Not even the systems managers are not very competent with it. So, the court managers, in fact, function to help the judges in dispensation of justice. That is the role of the court managers. Now, The what has been said in the All India Judges Association case also, and what is also generally said is the same terms which are being used in National Judicial Academy. And I'm really surprised as to why these terms are used in the functioning of the court managers. Now these terms are timeliness and responsiveness and quality of justice. I don't think that timeliness of deciding the cases, quality of justice, and responsiveness or the ultimate responsibility of the judges has got anything to do with the court managers. Court managers have a very important role in maintaining the court systems so that the judges are able to discharge their functions more effectively. And do not bother themselves with petty things, small things, and they can concentrate in all their energies in judicial functioning. So I would rather put it like this, that the court managers should be held responsible to give expert assistance or an assistance, scientific assistance of management in all non-judicial court functions. In non-judicial court functionings, they should not be held accountable for the arrears in the district court or the shortage of judges in the district courts or the shortage of staff in the district courts. They should be able to provide a good management systems. Now, what are the good management systems that we all know? We have the management practices in the courts had fallen to such a, I would say, disrepair that sometimes it was called that we are using bullock cart methods in the courts for dispensation of justice. Things have changed. Now we are no longer in the bullock cart for dispensing the court of justice. But then, even if we have been provided all the IT services and the money and the number of judges have increased, system is not managed properly. And I believe the court managers can do are discharging excellent functions in the management of the systems. Now, we all know that you have been given tasks of human resource management. You have also been given tasks of maintenance, procurement of the court requirements. But I would suggest you something more. And IT structure and maintenance of IT structure, data feeding, accuracy in data feeding, the correspondence with the High Court, organizing meetings, as well as maintaining the IT infrastructure and other things in the court in a proper manner. Now, there earlier was a little struggle in getting adjusted in that court system because what happens is that since I'm aware of these things, I can tell you that the present court staff of various levels, whether beginning from the watch and ward, the persons who are responsible for cleaning the court premises, up to the senior administrative officer level, they were not happy when you were brought into the system because they had their old customs. Every district court was being run on customs. It's very strange. It's really very strange. How can a court system run on customs? But that was, in fact, the way the things were going on. There was unauthorized staff sitting. The courts and offices had no connection with themselves. The practices which were developed were far beyond the Civil Procedure Code and the court rules which are there. And every district had evolved its own system. So that is why you were initially not welcome in the system, because you brought in modern techniques, modern methods. You brought in a new way of thinking in the courts, of understanding of the things. But now, since you have made the place, now the time is there to make some more innovations and bring in more ideas. Why I'm saying so is this: that the more you will be you will be felt in the system to be useful. You have to make yourself indispensable, totally indispensable. It is only then the high courts will stand for you. One thing I tell you, I went to attend one of the meetings of the Chief Justice's conference in 2014, 2015 March, as the Chief Justice of Rajasthan High Court. There was no discussion in about 2 days deliberation. There was no discussion on subordinate courts, methods, systems, and practices. There was not even a proposal. There was not even a word spoken in 2 days about court managers or for any other thing in the district courts. They talked about the salaries of the high court judges and Supreme Court judges. They talked about legal education and legal training. They talked about juvenile justice and all other things. But they never talked about the improving the court systems. They did talk about the IT infrastructure, but the IT infrastructure in 2014 was also not such which was worthy of mentioning, or it was going to help the court system because CIS was still under the development stage. You have to show your strength in such a manner that you should become indispensable for the entire system so that the voice goes not only, it should go from the law commission and the law commissions, it should reach right on the table of the Chief Justice of India. And it should be discussed in the Chief Justice's conference and Chief Minister's conference in such a manner that you are now an important part of the court system and court system needs you. You are so indispensable that a separate cadre has to be provided, providing for a regular pay scale, going up and up. There should be promotional avenues also, channels also. And I believe that the appropriation of court managers to the High Court was also wrong because it was mainly meant for district courts. Both courts function in entirely different manner. Now, if you put a person in the High Court and then you send him to the district court, he will treat it as demotion and then you will find a very different alien work atmosphere and work method of working there. You have to have promotional avenues of the court managers up to the level of High Court and even up to the level of Supreme Court. What is happening in Supreme Court today? Just see what is happening. We don't even have a good court management system there. I'm sorry, I've worked there. I've also worked as a chairman of the E committee, but we don't have that. You have to bring in people from the states. Every time the new Chief Justice comes, he brings a Registrar General, Secretary General from their own states. I found Mr. Goswami is a wonderful person, one who is working on the IT field. He came in from Maharashtra when I was there as a chairman of the E committee. But he also had his own problems and adjustment in the Supreme Court. Unless you have a regular cadre which moves from district court to High
You
Court
are
and then Supreme
unmuted.
Court,
अब
you will
आपकी
not be able
आवाज
to give
सुनाई
your
देगी.
best to the system. Now, yes. Okay. Oh, okay, I'll do that. Green.
You are muted. अब आपकी आवाज सुनाई नहीं देगी.
Can you see me now? Hello?
Yeah.
You
Yes.
are
Can
unmuted.
you see me?
अब आपकी आवाज
Okay.
सुनाई देगी.
Okay. So
You
I was
are
on the topic
muted.
that you have to make
अब
yourself
आपकी आवाज
indispensable.
सुनाई नहीं देगी.
And there has to be a regular cadre now of court managers. And the regular cadre which motions up to High Court and thereafter up to Supreme Court. Now, let me come to the suggestions which I want to give to the court managers. You've all been asked to prepare court development plans. I think in most of the districts, the court development plans have been prepared. But the court development plan you have been asked to prepare is for 5 years. That is unrealistic. You should have a court development plan for the next year. Now, I sometimes wondered as to how will you prepare a court development plan if you don't know the posts of the judges which are going to be created or the staff which is going to be created. But at least you can give those projections. And the court development plan prepared by the Allahabad High Court court managers was an excellent document. I admire them. Mr. Srivastava was there. I don't remember the names. That was a futuristic document which they prepared. And I think all of you are competent to do that. The next thing is the user's manual in the court. User's manual. Now, in one of the conferences in Bhopal, in National Judicial Academy, I came across a user's manual prepared by Mr. Wasim Khan, the court manager in Gadchiroli, Maharashtra. I wonder whether he has joined this webinar. This code development plan is an excellent document, which is an 82-page document, which gives a complete guide for any person, whether it's a litigant, employee, or it's the judicial officer, as to how to approach the court and how to get its work done and matters resolved. Uh, we also had a very good this court manual of Ajmer, prepared by this very dynamic district judge, Mr. Sharma. I think what you can do is, now another suggestion which I'm going to make to you today is that court managers should prepare a software, firstly a software. This software should be a model software that should be adopted in all the states, in all the districts. We should provide for all the duties and functions of the court managers, so that you are reminded every time as to what is to be done and what is not to be done. Whether it is in e-procurement, whether it is in IT matters, preparing inventory of the court assets, including the land of the asset, the court. There is one thing which I found that is not there in the court. If you go and ask any court as to where are the papers of the land on which your court has been established, how many times you have expanded, how much more land would be needed, what is the land actually used by the courts and other by the court lawyers, chambers and lawyers facilities in the court. Now, unless we have this inventory of the land, inventory of the buildings, inventory of the system of various facilities in the court, like we do not have the number of furniture we have, the machinery like you have lifts, photocopying systems, computers. Now we have inventory of the computers with the court system manager, but there is no general inventory. Another area which you will like to deal in the software which you will prepare is the accounts and budgeting. Accounts, and this is one function which the district officials do not want to delegate to you, or even hand over to you, or even seek your supervision or assistance in that, because this lies in the wraps of mysteries in the court system. Because every court has a budget, money which comes from the state government for salaries and other things, and then the courts also have the registers of fines, penalties, duties, as well as the two important functions like where the motor accidents claim compensation is deposited, the land acquisition compensation is deposited. These are the areas which should be given to you. Apart from budgeting, preparing the budget of the court in a very scientific manner, you should also be given the accounts, which is this is really why the courts became a place where you were not accepted very easily, because there are stories and stories as to what happens in the courts, whether it is a record room or library or the accounts or the budgeting. But now, since you are there, you have now a good experience of 5 to 7 years, you would perhaps be understanding it a little more. These are the areas where you already have an expertise. But all we need, I proceeded with that with the software. Now the time has come from e-tendering. All procurement through e-tendering, whether it is an IT infrastructure hardware, or it is the motor vehicles for the courts, or it is the photocopying machines, anything. Now the e-tendering process has been put in place by almost all the states. And I believe that you are the best person to do it. I remember that when we had purchased computers for the first time for Allahabad District Court, I was the portfolio judge there. The district judge was not prepared to purchase the tables and chairs, because he said that in all financial matters there is some other thing wrong. So I had to go myself and select those tables, and I said, you will take this chair, and I give the approval right there. Those are the hiccups which are there in the systems. Then another area which for which it can help you, software can help you, is the compliances. Now, a very heavy burden has been put upon you to respond to every request made by the High Court or which comes from the Supreme Court, as well as the state assemblies and the parliament about. And most of these requests are about statistics. How many cases, how many judges, how many decided, how many not decided, and you have to provide these details. Now, CIS does provide. CIS also provides for e-tendering. CIS also provides for reports, but these reports sometimes are not consistent with the requirements of the provisions given in the CIS. So your web software can provide for your requirements also. What are your requirements of your compliances? These are one in many, so many of them. Every now, I think there is hardly a day when the request does not come from the High Court to provide statistics or other things. Then now you have been given an added responsibilities of the various type of specialized courts also. There are family courts, there are juvenile justice courts, there are legal aid authority functions, there is a Lok Adalat going on almost every week. Now, court managers have been given these functions. You should have an appropriate software for this also, so that in your free time, you can sit, look into the compliances, do whatever is needed. Another area is conferences, arranging meetings and conferences. Now, every district judge has now and then has to meet the district magistrate. He has to meet the superintendent of police. He has to call for the meetings of the commissioner and give him these difficulties about service of summons through the police and blah blah blah. And now these are the meetings you can organize. You can organize periodically, because many a times we find that meetings have not been organized for months together. So, and this web page should also have a provision of new ideas. The web page should also have a proposal for standard operating procedures for the court managers. New ideas by court managers. Many a times I have found, like in this case of Mr. Wasim Khan, he prepared the court manual. You can also come across many requirements, needs on which you can give your thoughts, come out with new ideas. Now I'll tell you what happened. And day before yesterday's conference, I felt that this is one area where the court manager can perform, give his best, and make him more indispensable in the court system. Organizing webinars, video conferencing. Now today, in this COVID pandemic lockdown, the courts have become conscious of the need of e-filing and the hearing through video conferencing. I can tell you my experience committee. We had just started the module of e-filing, and we found it very difficult because there was no 24/7 staff in the Supreme Court. The servers were not up to date. The Supreme Court staff did not know what is cloud computing and how to go on clouds. Supreme Court was not connected with the NIC servers. So how would you do the e-filing? Now, all those things are being done now because of the need. And here is one area where you can be proved useful, because your systems manager also is not very capable. I have found I've talked to those system managers. It is you who can guide them. We provided for.
Is it clear?
Hello?
Yes, Lordship.
Am I clear?
Yes, Lordship.
Okay. Now, what you can provide for is a systematic and a scientific way of e-filing, for which the technology is already available. And for e-evidence, e-conferencing, video conferencing, and virtual presence, these modules are already available in CIS. All that they have to be activated and used. Our Chief Justice of India and Justice Chandrachud said that we have been doing a lot by video conferencing. I have my great doubts, because we are not prepared for that. There may be some states like Delhi, Punjab. I asked about one of my friends as to what is the progress in Bombay High Court. He said, "Sir, I cannot explain to you, but lawyers are finding it very difficult." You cannot have e-hearings, e-evidence, unless you have e-filing. How many states are e-filing? I'm not going beyond the topic. All I'm saying is that here you can come in and help. You can volunteer for help. Now, since the message is coming from the Supreme Court in these distress circumstances, you can jump in and ask your district judge and your chief justice that I can provide the help. I can coordinate these services with system manager. We have these facilities in CIS modules for having these hearings by video conferencing, and make yourself more and more useful. So I think I have consumed my time of about 20-25 minutes.
My lord, we would be happy to hear you another 10 minutes, and then we will take the question and answers.
Okay, can you tell me the area in which you would like to have some more discussion?
So far, Lordship, we have been able to get all the information, all the knowledge from your Lordship. Whichever area you feel comfortable, we just guide us.
Okay, no, so let me go back on a little on the inventory system. Now, my experience of the High Court and District, I'll tell you one very interesting experience. There was a massive strike in Kanpur. You know, Kanpur has the biggest judiciary in the district judiciary in the state of UP. There are about 80 to 90 judges in the subordinate courts. In the year 2012-13, there was a big problem. There was a fight. There was some scuffle between the lawyers and the police in the court system. One of the police officers was virtually kidnapped and confined to one of the judges' chambers, and there was a massive strike. The genesis of that strike was, and I tell you, the genesis always is the lawyers' motives. They wanted the bail jurisdiction to be restored to the first additional district judge, who was pally to some of the lawyers. The new district judge wanted all bails to be heard by himself. Now, the strike was so big and so massive that the Chief Justice requested me that if I can take over the Kanpur as a portfolio judge and try to resolve the strike. My first request to the Chief Justice was that I should be given the district judge of my choice. So the then district judge, who was very good district judge, he wanted to do all bail matters himself, and he did not accept to the request of the lawyers. So, but the Chief Justice accepted. He was transferred, and I was given a district judge who was my friend from the bar. And I told him to adopt a new approach to the lawyers' strike, entirely new approach. And that approach was that we have, by neglecting our court systems for years and years and rather decades, brought it to a level where it is almost non-functional, or it is functioning only to the advantage of a couple of lawyers or a group of lawyers. And the court systems have become so rotten that both the lawyers and public are not happy with it. And our idea was that if we can restore the court system back to good, from worse to good, we may be able to bring in some sense. So we proceeded on daily meetings. And you know from where we started? We started from cleaning the court premises. My district judge helped me to remove 10 trucks of garbage from the district courts. Then we started removing those unwanted places from the district. All lawyers have extended their chambers. There were hundreds of commercial establishments, pawn shops, beetle shops, tea shops inside the court premises, where they were not only selling beetles and pans and cigarettes, they were also selling contraband, some narcotics also. We removed them. We could not request the lawyers not to bring firearms inside the court premises. That was also there. We found that sometimes the litigants are beaten up inside the court by the lawyers. A very serious thing, which happens, and we do not notice them. Then we tried to find out what are the places where we did not blame the lawyers. We said, what are the places? Then we found that this is about 7 to 8 story building. There are 4 lifts, out of which only 2 lifts are operational. So there is a mad crowd going into the lifts and climbing up. One lift is dedicated to the judges only. So only one lift for senior lawyers and the litigants. And they had to go through the ramps and staircases. And the lawyers had taken out the bulbs from the corners of the ramps and staircases. And there they would accost the litigants and beat them. on charges. So what we did was we did not catch the lawyers. We gave the maintenance contract, got the lifts improved, all 4 lifts functional. Judges will use them for only 2 hours for going in the morning hours and evening hours. The rest of the time open for litigants also, so that nobody has to use the ramps. And we found that the police outpost was placed at a very odd place. The police outpost was placed right in front. We asked the striped police constables to sit in front by putting their chairs. And we also made the order that in all heinous offices, the accused will be brought only by the starred inspectors and not by ordinary policemen. All instances of beating up the litigants came to an end. Then we found that by passage of time, the distance between court and offices, which should be near to the courts, were gradually, a court is on the first floor and the office is on the 4th floor. Court is on the 5th floor and the office is on the 1st floor. So we brought all of them together. We found that the courts in which there was a maximum crowd, the maximum footfall between 10 to 2, that is the magistrates' courts, were all sent on upstairs. And the civil courts, where there used to be hardly any presence of lawyers and witnesses, was on the ground floor because of the need of lawyers. We placed them back. We found that almost 60% to 60 to 70% of the summons of the courts were not served personally by substituted service. And in almost all files, the unserved summons were kept until and unless somebody will give some money to the concerned clerk to send the summons. That was taken care of. We found that thousands of remand matters were pending. Thousands of matters of committals were pending. Thousands of matters of succession certificate, uncontested succession certificates were pending. We tried to find out at least 30-40 areas where the court systems had virtually broken and restored them. The decision took 6 months of time to restore the systems. Strike came to an end by itself. The lawyers and litigants were praised. They had a lot of praises for the district judge, the new district judge. And when the new district judge gave the charge, he was given a big farewell, and lawyers contributed for providing furnitures in the court. Why I'm telling you all this is that once the court systems, by passage of time or by practices or by lawyers' requirements or by needs or by neglect, fall to a level where they are functional, but they become totally disorganized, it becomes very difficult for the lawyers who have themselves spoiled the systems to function in that system. The mediation center was set up on the 6th floor, the top floor, where there would be maximum crowd, where the family matters had to be mediated. It was brought down to a very comfortable, congenial room with good curtains, flower pots, and a good atmosphere. These are the areas where you can work. You can work, and I tell you, nobody will stop you. Your portfolio judge will be happy, your district judge will be happy, and gradually you will make them indispensable. Bring your matters to the High Court table in the full court meetings. Your matters should be put in the full court meetings as to why the court managers are being ignored when they are putting such great services in the district courts. Prepare such things that it becomes easier for the district court to function. Once again, I'm telling you, I deliberately chose this topic, negative topic. You are not responsible for dispensation of justice, but you are responsible to do all non-judicial functions which help the judges to discharge justice, because that's the primary function of the court. That's why the litigants come to the court. The more you will make yourself indispensable, the more your services will become better, the more court systems will improve, the court managers will be required, and they will be required forever. And now the time has come that every law school should also have one paper on court management. Way back, about 30 years back, I found one notice in Supreme Court when I was an advocate in record there, that ILI, Indian Law Institute, is starting a course in collaboration with an Australian university about court management and justice management. But by the time I had put in about 10 to 12 years of practice, the young people could have taken it. But the idea of court management, the need of court management, the requirement of good court management should be taught to the students in the law school itself. It should also be part of the training program of the judges in the judicial academies. You know, I've been going to judicial academy for 10 years and I've attended only one session on court management, on court managers, whereas there should be regular sessions. I don't know why, but they don't call you. Court managers should be called for training, for specialized training, not through judges, but by your own management institutes. I think I have consumed that last 10 minutes also. Now,
Absolutely.
can I have some questions? How would you like to put the questions? On the screen or?
On the screen, there is a public chat, Lordship.
Yes, the public chat is there. I can see that. I can see all the greetings there. Mr. Manmeet Singh Arora has asked, sir, how can we differentiate the work of court manager and registrar civil courts? These are two different functions altogether. Registrar civil court is a person who is responsible for filing, scheduling, allocation of work through the district judge. The registrar is also overall responsible for the functioning of the court. Wherever there are vacancies, where the work is to be transferred, where the important information is to be given to the High Court, you are not required to do the work of the registrar of the civil court. That's what I said, it's a misnomer. See, I found somewhere that the court managers are being held responsible for adjournments. What have you got to do with the adjournments? You are nobody to grant adjournments. You cannot even limit or contain the adjournments. It is between the lawyer and the court. If the courts are giving adjournments, now there's a ban on adjournment beyond 3 adjournments in the civil procedure code. Nobody follows it. If you follow, the lawyers will go on strike. It is not your function. Your function is to strengthen the court systems. If the registrar tells you as to in what scientific manner I should allocate the work, you should step in and help him. But don't interfere in his functioning of scheduling, allocation, appropriation of courts and other things. Yes? Any other question?
Lordship, I have a question.
Yes, please.
Lordship, you have suggested excellent suggestion to have a software with model roles and duties and functions of court managers.
Exactly.
To take it forward, I would like to have your Honor's views if we can have such uniform software developed by NIC, which would be applicable to all over India court managers, and it will help everyone to have the uniformity. Could you please provide your views?
Absolutely, absolutely. They have an excellent team in Pune. NIC has an excellent team which is looking after the CIS, case information systems. It was not difficult for them to develop a software for you on an open source platform, which can be modified also according to your requirements of the states. If suppose your state,
Yes,
High Court makes certain requirements, special requirements from the district courts, you can include in them. But that software should include almost all the functions, duties, and responsibilities so that you can very easily attend to them, complete that. There should also be a communication channels in that software so that you can send the messages to just as e-tendering is concerned for purchase. Preparing the inventories